Welcome to week 12. We are still talking about the judiciary, but we are going more in depth on the Supreme Court this week and talking a little bit about the processes and the justices that fill the roles there. So the Supreme Court is composed of 9 members. Why 9? That's what the Congress has settled on as of right now. In fact, there's nothing within the Constitution saying how many members of the Supreme Court there are or ought to be. Supreme Court members are appointed for life, which will form the subject of our next debate this week, or until retirement, or so death, retirement, or impeachment, which is possible. They are appointed by the president, confirmed by the Senate, and I think we all know from the past couple of years that those can be somewhat contentious at times, although sometimes they are less so. There is a Chief Justice who is the lead on the court. There must be a vacancy in the Chief Justice role, meaning the Chief Justice must have died or retired for there to be a new Chief Justice. It's not something that can just be rotated or something like that. The president must assign a Chief Justice. And the president can choose from current justices already on the court and make one of them a Chief Justice, or can pick a new justice who will be both a new justice and the Chief Justice, as was the case with Chief Justice Roberts. So we have associate justices, 8 of those, and a Chief Justice, 1 of those, making up the 9 on the court. Now, for those of you who don't know why there's a picture of dogs on your screen, that is because that is from John Oliver's witty takedown of the Supreme Court's refusal to allow cameras into their hearings. And so he kind of made his own court out of dogs. The reason why I am using an older picture of the court is because those are the dogs that are representative of these people here. There is footage up online where you can make your own Supreme Court hearing videos using these dogs and the audio that the court does provide. So that is why I have it there. We don't get to see a lot of the justices in action. We see them give speeches. We see them give interviews, but we don't see them in action on the bench other than courtroom drawings. So, my favorite dog, which was the Scalia dog, so much for that. So, an anatomy of a Supreme Court appeal. First, we should probably talk about the ways in which appeals come about, and there are 2 major paths for an appeal from lower or other courts. The first is the one we think of most often. It is the most common, which is a federal court appeal. This means that there is a case that originates in a district or lower court. It goes up to appeal at the circuit court level and then eventually gets appealed up to the Supreme Court. This is usually only taken on by the Supreme Court because, remember, they can reject appeals. They don't have to take them all, and they certainly do not. Reasons why they might take it include something like a circuit split, meaning one circuit treats something some way and another circuit treats it differently, or if it's an issue of national importance that deals with the president and national policy, or something of the like. Now, there are other reasons why justices might be interested in taking in cases, but you need at least 4 of the justices to agree to take a case before the court agrees to move it on to its docket. The other path, option 2, is up through the state Supreme Courts. If the state Supreme Courts decide something that is a matter of federal constitutional law, the United States Supreme Court can hear an appeal based on their decision. Now, this is only the portion of the decision that is based on federal constitutional law. The state Supreme Court decision that deals with state law or state constitution cannot be reviewed by the Supreme Court. Again, the decision to take these cases is one that the court makes. They are not automatic, and it depends on differences, usually in how different states treat this and whether there, again, is a circuit split even that other cases have reflected as well, or if it's something of national importance. Odds are, if it's coming up from the state courts, it's going to be something involving criminal protections for trial or for search and seizure or something of that nature, criminal procedural protections, and that will go up that way. All right, so we need to also think about the steps in a Supreme Court case. So I'm going to break those down for you here into 4 concrete areas. The first is the petition stage. Next, we have the written briefs stage, then the oral argument stage, and finally, opinions. So going back to petition for writ of certiorari or writ of cert, the petitioner is the party that is appealing to the Supreme Court, who wants the Supreme Court to overturn what the lower court or courts have done. The respondent is the party that is not appealing, that is probably happy with the decision below. You must apply to have your case heard, and that is what the petition is for. You need to be granted a writ of certiorari to be able to have your case heard on appeal at the Supreme Court. So the first round of everything, whether it's briefs or just going to the court and getting a case number, all of that is the petition for writ of certiorari stage. So the briefs at this stage aren't geared necessarily to the substantive issue of the case, although that's involved, but it really focuses on why the Supreme Court should take the case, why it's important that the Supreme Court gets involved at all. Less than 1% of all cases that apply for a petition, petition for a writ of cert, less than 1% of all of those cases actually get cert granted and move on. So it is likely that if your case goes up, it's going to fail at this stage. So it's okay. You're part of the 99%. You're in fairly good company. The next stage is the written brief stage. Now, there are written briefs in the petition stage. These are new briefs. These are the substantive briefs that the court will decide the case on, along with the oral arguments. So petitioner files the first brief, just like in the petition state. The respondent files a reply brief, and there's a series of responses. There are also briefs from parties called amicus curiae. These are friends of the court who feel who the court has granted permission for them to file a brief on behalf of one outcome or another, or provide additional information. And then there is the Solicitor General. The Solicitor General represents the federal government when it is a party to a case at the Supreme Court. In addition, the Supreme Court can request the involvement of the Solicitor General, even in cases that don't directly involve the federal government, if the court feels that the federal government's opinion might be relevant. So they would invite the Solicitor General in to give the government's position on a case and argue it there as well. So after this stage, all the briefs are filed. We move to oral arguments. Oral arguments are a given time where the parties can come present their case and justices ask questions of legal counsel for the parties. Both parties are given time to present. The presentations often revolve around justices' questions, which they will throw out as they see fit, and you as counsel have to respond to them. As I mentioned before, there are no cameras, there's no video, there's no photography in the court at all. There have been a couple of times where this has been attempted and people have gotten penalized for it criminally. It is a crime to bring a camera into the Supreme Court. Instead, they release audio and a transcript, which some people argue is not enough. Oral arguments probably don't go a whole long way to change the justices' minds, but they do help shape legal arguments that you'll see later in the opinion stage, which is where we're headed next. In the opinion stage, we will usually get multiple opinions in one case. The majority opinion is, like it says, the opinion of a majority of the justices on the court. And it ends up being what the case stands for. It ends up being the law that the case makes. The dissenting opinion, or opinions, are minority views that disagree with what the court has done, what the majority opinion has done. Concurring opinions agree with the outcome, but disagree with the methods or way in which the court went about going to that end necessarily. Per curiam decisions are interesting. They are decisions of the entire court without authorship attributed to one justice or to a group of justices. There are some notable per curiam decisions in the history of the United States. Bush v. Gore, for example, in 2000 was a per curiam decision. No one wanted to put their name on that one. And then unanimous decisions. You'd be surprised. We don't tend to hear about these, how many decisions are in fact unanimous. But that, as it sounds, is a decision that the entire court, the entire bench agrees to, all of the justices. So the Supreme Court does have its own original jurisdiction. And when I say original jurisdiction, I mean the ability to hear cases for the first time. Article 3, Section 2 outlines the court's original jurisdiction, and it can hear cases under this section that involve disputes between states, meaning state A sues state B, and this is the way in which if let's say Michigan is suing Ohio, it has to go directly to the Supreme Court. No other court can hear that case. We'll talk about what that means in a minute. Actions involving ambassadors or other public ministers of other nations, controversies between the United States and a state, and actions or proceedings by a state against citizens or of another state or of of non-residents of the United States. So, what really happens here? First of all, let me say that number one, if you have a dispute between two states, that has to go to the Supreme Court. 2, 3, and 4 can go directly to the Supreme Court, but most often go to district courts and flow up naturally that way. So the only one that has to go up is number 1. Now, what really happens in these situations is that the Supreme Court appoints what is called a special master. They pick someone from a lower court, usually a lower court judge who deals in trials and trial procedure every day, and they handle all of the proceedings down below and prepare a report for the Supreme Court with a recommendation. The Supreme Court can deny a hearing in any of these original jurisdiction matters, and often does. Usually about half of them are just outright denied. But there aren't that many of them to begin with. The court is lucky to get one a year at this point. And so we don't see a ton of these. They don't make a ton of law. And most of the time now they really deal with border disputes or pollution issues over a border, things of that nature. They don't typically involve things we would hear about on a day-to-day basis. So we have to talk about the demographics of the Supreme Court justices. It is something that is not only kind of the elephant in the room, but is of great importance as well. Up until we had Thurgood Marshall, the entire Supreme Court was white men. And up until we had Sandra Day O'Connor, the Supreme Court was men. And that was 1980. So we're not talking about ancient history here. We're talking about the fact that up through the mid-20th century, we had no one other than white men on the Supreme Court. Now, is that, by definition, a problem? Some would argue yes, some would argue no. That said, it does represent a glass ceiling for a lot of people that might otherwise want to be represented on the nation's highest court. Currently, only 4 women have ever served on the Supreme Court. 3 current, Justice Sotomayor, Justice Kagan, and Justice Ginsburg. And 1 retired, Justice Sandra Day O'Connor, who was the first. Only 2 black people have ever served on the United States Supreme Court, 1 currently, Justice Thomas, and Justice Thurgood Marshall, as I had mentioned before. Justice Sonia Sotomayor is arguably the first person of Hispanic or Latino heritage on the court. although some consider Justice Cardozo Hispanic, so there is some debate there. The current composition of the court is predominantly Roman Catholic and Jewish, although that could change. Now, the big thing is the court is fairly old. Even with the addition of Gorsuch and Kavanaugh, these are people who have distinguished careers, and therefore, to have a distinguished career, you have to have time to do that. And therefore, the median age of the justices is well into the upper 60s, if not mid 70s at this point. And so we have people that are not quite representative of the general public. Now, like this political cartoon points out, there's another type of lack of diversity on the court, which is that all of the justices on the Supreme Court went to elite Ivy League law schools. Not just elite law schools, Ivy League law schools, Harvard, Yale, and I think we're still at Harvard and Yale only for law schools. So does it represent the entire legal profession? No. Does it represent the entire United States? Absolutely not. Should we strive for greater representation? Probably. We have some research that shows when gender is balanced, there are not necessarily different outcomes, but maybe more careful consideration of different types of cases and that type of thing. So these things are important to understand, and research shows that in many ways they do matter, although we have a very small sample size for some of them. So, lifetime terms for all judges, the judicial branch broadly, was thought to be a way in which to protect judges against political interference from Congress and from the president. Hamilton noted in Federalist 78 that unlike Congress and unlike the president, the justices of the Supreme Court and the lower court judges were somewhat powerless. They didn't have a good defense. And so allowing them to be independent when they would inevitably come into contact with other branches of government was very important. And the one way in which the framers thought that they could do this was to make it so that they didn't have to rely on, whether it was re-election or reappointment, they didn't have to rely on anybody else to keep their job. So they weren't beholden to anybody except for beholden to the Constitution and the people. The question is, though, whether these reasons have changed or faded over time. Maybe judges and justices are more powerful than the framers anticipated. Or maybe the framers were just wrong, and the justices, at least, on the Supreme Court don't need the same protections as maybe lower court judges do. So the readings this week center around that question of whether there should be term limits for Supreme Court justices. Now, for our debate this week, I'm leaving that open, what those term limits might be. There is a proposal that you'll read about 18-year term limits, where at least every president knows they're going to get so many in every term. I'll let the readings deal with that. There's no need for me to go into that. You can read it and analyze it from there. So the pro side will be arguing that justices should not serve for life. There should be term limits. They should not serve for life. The con side will be arguing that justices should have a lifetime appointment, that there should be some way in which they are separated from the political fray, and the lifetime appointment is one way of doing that. Now here's the twist. I am going to let you pick your side this debate. I have thought about this one a lot, and I think that we probably have enough of an ideological balance on this question that this will work out. So, at the beginning of your statement, please state clearly whether you are arguing the pro side or the con side, and then go ahead and give your normal statement per usual. All right, if you have any questions about anything this week, the readings or anything like that, you know where to find me, and I am available by email, or you can also text or call me on Google Voice. Thanks. Have a great week.